This is Everything Real Estate with me, Dee Dee Richards. And today is all about trust and what it is, when you need it, when you don't, how it helps you, and all of that. So my guest today is Barbara Pretlove. She is a trust and estate planning attorney in Morgan Hill. And she's going to walk us through a few different questions and then a scenario that I put together talking to a friend of mine last night. I thought this was kind of a perfect storm scenario that we could discuss. Before we get into it, I just want to acknowledge, I think it would be unpleasant to acknowledge all of the challenges that our communities are facing right now and that we're facing as a country. And it did have a couple people say, you're still doing your show today? And I think it's important to continue on with life as normally as you can. Of course, we're in the middle of a pandemic. We're having a lot of societal and racial issues, and it's a really hard time in our society and for our country, and really as far as the pandemic goes for the world. So I didn't want to start this without just acknowledging that. And we all have our different ways of dealing with it. For me, I'm very ingrained with our community, and I love our South County community. I grew up here, and it's a part of me. So for me, it's supporting my community, reaching out to see how I can help, and being a voice for anyone that I can, and lending a hand wherever I can. So however you can help, however you feel you need to deal with what's going on in our world and our society, please do. Be safe and be kind to others around you. So with that, let's get on to today and learning about trust. For me and my business as a realtor and consulting with people about their real estate, it's so important for me to help people build wealth. And real estate, I really believe, is one of the best ways that we can do that. And trusts also help us build wealth for our heirs, for our family. And this is a little bit about me. You've probably seen this before. I'll show it again at the end. And our guest today is Barbara Pretlove. She is a local attorney, as I mentioned. Her phone number and email and website are there. And for me as a realtor, I said, I wanted to help you build as much wealth as possible. It's important for me that you hold on to as much money as you can regarding your real estate asset, and that you move around the pieces of your real estate asset as best as you can to make as much money as possible. I truly believe that real estate is one of the best ways to build wealth in our country. And in order to do that, you have to understand what to do with taxes. We were talking about 1031 exchanges last week. You need to understand what happens to your real estate when someone passes, if it's owned by two people, what happens when one of those people dies, passes on, and leaves behind another person that owns that home. What do they do with it? So that's what we're here to talk about today. We're going to cover the explanation of a trust, and Barbara's going to tell us all about it. There are some different types of trusts, so she's going to talk about that. And then when do you really need one? Not everyone needs a trust. So when do you know you need one? And then what happens if you don't have a trust? That's kind of what we're talking about here, building wealth. And what's the difference between a will and a trust? Because I have a lot of people that say, well, we've got a will. Doesn't that do the same thing? And then we'll talk about that scenario that I was thinking about last night with a friend of mine. A married couple owns a home. One of them passes away without a trust on the property. The surviving partner needs to sell that house. What happens? So we're going to talk about all of that. And let's just dig into it with Barbara. And I'm going to put her information back up on the screen. So Barbara, why don't you do a little explanation for us of what a trust is?
Sure. So a trust is really just a legal document that allows you to transfer your property into the trust, which is its own entity. And it's the way you hold title to usually your real property. You can be bank accounts and anything like that. And it allows you to distribute those assets to the people you choose while avoiding probate. And that's, for most people in California, that is the biggest reason to have a trust, is to avoid probate. Our tax exemption for estate taxes is so high. Each person has $11 million in exemption. A married couple is a little over $22 million. So until you're over that $22 million mark as a married couple or $11 million as an individual, you don't need a trust for complicated tax planning. Again, it's really just to avoid the probate process in court, which is lengthy and very expensive. And then the different, go ahead, sorry, Dee Dee.
What's probate? What's so bad about probate?
So probate is what happens when you don't have a trust. If you have over $150,000 in assets, which if you own a home out here in California, you probably have more than $150,000. And that's decided by the fair market value of your home, not the equity you actually have, which I find that kind of an odd way to determine that, but that's how the courts see it. If you have that, then it's a process through court. Even if you have a will, it's supervised by a judge. There's deadlines and a whole process that you have to go through. It takes about a year to work through this process and distribute the assets among the beneficiaries listed in a will. And it's very expensive. The attorney's fees are state mandated, and it's a percentage of the estate, which can be very high. A $500,000 home, if that's the only thing in the estate, the probate will cost around $15,000 to your attorney. The same amount gets paid to the executor, who's responsible for distributing all those assets. And then on top of that, you have your court fees, your publication fees. It has to be published in the newspaper, and the probate referee appraisal fees. So it just kind of keeps ticking up and up and up. When you do a trust, you avoid all of that. You don't have to go to court. You don't have those fees. Attorneys usually set their fees on an hourly basis, which is a fraction of the probate cost. And it doesn't take up to a year. It can if people are contesting and arguing, but you can do it in a much shorter time frame.
Wow. So the only reason you would need to go to probate is if you want to sell the property, right?
No, if your house is in a trust, you don't need to go to probate. But if you don't have the trust, you have to probate absolutely everything, whether you're selling the property, if you're just inheriting the home. If you don't have a trust and it's over $150,000, you have to be in probate no matter what, unless the home is in joint tenancy. And we'll get to that at the end. There's ways around it, but for the most part, it doesn't matter if you're selling the home or inheriting it. You have to go through probate if there's no trust.
Oh, gosh. Okay. So let's say I inherit a house from a cousin. Okay, an aunt is more likely. My cousin's probably not going to give me their house. But, okay, so an aunt who doesn't have any other kids, she's going to heir or will me her house. And I just want to live there. I don't want to sell it. I just want to move into it. I still have to go through probate?
Yes.
Oh.
You have to go through a process. You have to get the house appraised. You inherit it through that. There's no way around that process. The only way you'd be able to avoid that would be if she did a transfer on death deed, which is its own set of issues, or put you on title as a joint tenant, which if you did that, then that triggers, you wouldn't get the capital gains stepped up in basis. So there's tax issues that get triggered by that as well, whereas inheritance is the best way, but you want to do that through a trust, not leaving it in the will.
Okay, and who pays for the cost of probate? In that example, obviously my aunt has passed on. So if she hasn't left money to pay for that, do I pay for that?
It's the estate. The estate does pay for that. So it would come out of the house. So if it were you, if there's any liquidity at all, or you could get, pull out a loan from the home to pay the fees, the fees really aren't paid till the end of probate. So you have time to, do an estate sale, get some liquid assets from maybe vehicles being sold. You can foot the bill personally and get reimbursed by the value of the house without doing a mortgage. So there's ways to work with that, but essentially the estate does pay for the probate.
Okay, great. So if anyone has questions on that, please put them. Brittany, we want to put them in the chat, right? And then we'll answer those questions either as we go along or at the end.
Yes, please.
Okay, thank you. Because this is a little complicated. And I'm learning a couple things too that I thought I understood, but I apparently don't. So what are the different types of trust, Barbara?
The main trust, as I said, is a simple probate avoidance trust. That's what most people need. There's also A/B trusts, which happen when you want to plan for blended families and have kind of two separate trusts branch off to protect each person's children to inherit the funds. There are special needs trusts that come into play when you have a special needs child or beneficiary that you don't want to affect their social benefits. If they inherit, they'll get kicked off Medi-Cal or anything else they may be receiving. So we want to make sure that inheriting money doesn't affect that. That's a special trust setup for that. There are irrevocable trusts, which are typically used for Medi-Cal purposes. So you would still be able to qualify for Medi-Cal without spending down all your income and being completely impoverished, where we get that out of your name, and that can be used as supplemental funds for you while you are on Medi-Cal. There's a slew of other ones. There's lifetime beneficiary trusts. There's where you can give someone a house to live in for the remainder of their life, and then you control where it goes once that person passes away. I mean, it's almost endless, all the types of trusts that are out there, but those are the main ones.
The most common one I hear about is a living trust.
Yes, and that's your regular probate avoidance trust as a living trust, right? And that's revocable. You can change it as many times as you want, so long as you have the capacity to do so.
What does revocable living trust mean?
It means you can revoke it or amend it or change it at any time.
At any time.
Mm-hmm.
For any reason.
For any reason.
Yeah, that's the most common one. The revocable living trust is the one when I'm taking a listing or I'm working with a buyer and they want to put the house into a trust, or where, you know, presenting they're taking care of the documentation for someone who owns a property but needs to sell it. It's in a revocable living trust. It's probably 99% of the time.
Right.
Okay. And you touched on this. When do you need a trust? You said if you have assets of $150,000 or more. Is that just real estate, or is that all assets like your 401k and other investments?
So it's all assets in the aggregate that add up. Your 401k has a direct pay beneficiary, so that completely avoids your estate.
Oh, true. Yes, that's right.
So you can list the trust as a beneficiary of your 401k if you'd like it distributed through there. I do always recommend that if someone has minor children that would be inheriting, you want to be able to maintain that in the trust and have that already set up. But aside from anything that has a direct beneficiary, all of those assets in the aggregate, if they are $151,000, you will be in probate. Okay. If they're under that 150 mark, there's a simple small estate affidavit you can file and you're done. You can void court. But once you hit that threshold, or even are close, you really do need to get a trust.
Yeah, and that would, like you said, for most people in California that own real estate, you're well over that.
Right.
Yeah, okay. So we talked about this as well. What happens if you don't have a trust? You go into probate, whether you just want, and it's hard, that's hard to believe that I just wanted, my aunt gives me a house, she passes, she wills it to me, or I guess she doesn't have a trust, so she wills it to me. I just want to move in, but in order to put the house in my name, I have to go through probate.
Correct.
Yeah.
Even if there's a will, it doesn't matter. The will automatically goes through probate. The only way to avoid that is the trust.
That was the next question. What's the difference between a will and a trust? Because I do talk to people about, well, do you have a trust on your property? They own 3 houses. Do you have a trust for your properties? No, we just have wills. So, right.
And the will get, you know, your property where you want it to go. You're allowed to dictate who does that. We always do a will with a trust. The will acts as a safety net to make sure your property does end up where you want it to go. And the will gives, the way we set it up, the will gives everything to your trust to make sure nothing's missed or forgotten about. And if you have minor children, the will also has the guardianship clause in there where you nominate those people to take care of your children. But aside from that, the will really doesn't do too much. It just really reverts back to the trust and says all assets are divided under the terms of the trust.
Okay. So let's talk about the scenario that I mentioned, and maybe it has a little bit to do with how the couple is vested. So a married couple owns a home, one partner passes away, they do not have a trust. The surviving partner now needs to sell the house to liquidate that asset and have money for the rest of the family. What happens?
So like you said, it does matter how the title is vested. If it's vested in joint tenancy, it's really not a big issue. The surviving spouse by law gets the house. There's no probate. The only thing they need to do is sign an affidavit of death with the death certificate that gets filed with the county and becomes the new deed, and essentially takes the decedent's name off of that deed and just vests it in the surviving spouse. If it's community property, you would think that that would be okay. It's actually not. It has to have, if it's vested as community property, it has to have the phrase with right of survivorship.
Right.
If it does not, you can still avoid probate, but it becomes what's called a spousal property petition. So that still has to go up to court. It still has to be petitioned to the judge for them to get a court order to say, okay, now you can take the rest of their community property. If it is joint community property with joint tenant, or sorry, with right of survivorship, then it's the same as a joint tenancy and they would absorb it. So it's not the worst as long as you're on the same title as a married couple. But if it happens to be in tenants in common or something else, then that section of the house, that half that's in tenants in common, would go to probate under the decedent's estate.
Okay. So what we're talking about, for anyone who's a little unfamiliar, how you hold title on your property is called vesting. So if I'm single, it would be Deneen Richards, an unmarried woman, as her, it wouldn't be sole and separate property, it would just be an unmarried woman, right? If you are married, maybe Bob is married to Sally and Bob's taking title as just a single, not a single guy. He would be it would be Bob Smith, a married man, is his sole and separate property. So how you vest is actually really important for not only real estate purposes, ownership, taxes, but also for what we're talking about today, a trust, and how that property passes when, if you are together with someone, if you're buying a property with someone else or many people, how you're vesting that property is really important. So Barbara, do you give advice to people on that sort of thing as well? If I'm buying a property or have a client that's buying a property and I'm confused, because there's a lot of different ways you can vest.
There are. Yes, and I do. That's the first thing. When someone has a property, I pull up their deed and I look to see how it's vested. Typically, when you put it into a trust, that automatically transmutes it to community property unless the trust is set up specifically to maintain separate property as separate property. So once it's in the trust, we're usually fine. But I do speak with a lot of clients that have inherited separate property. They want to keep it that way. And so we do keep it that way in the trust. But I do speak with a lot of people. Some people don't want to bother with a trust. They just want to fix their deed, and we do that as well.
Okay, very good.
I have a question in the chat box if I can throw that in there.
Absolutely.
Sure.
This is from George Wong. He said, Barb, I had a trust done 15 years ago. A lot has changed since. Even the lawyer who did my trust, I can't find him anymore. He's probably retired. Do I need my trust to be reviewed again? How can I ensure the new assets I acquired since then can be included? And as a kind of an offset question to that as well, do I keep the trust document and just show the judge if either my wife or I pass away?
So I'll start with your second question. When you have a trust, you do not have to go to court. You don't have to deal with the judge. It's all privately done, which is really nice. And you don't have to deal with the court system. To your original question, I always recommend every 3 to 5 years, you should get your trust reviewed. There's so much change in the law that sometimes you need to update it to include the proper verbiage that will help get your trust administered without any kind of hiccups due to those law changes. And so I would definitely recommend getting it reviewed. Most of the time, we try to make sure if you bought new property that would be titled in your trust, or any new assets, any large savings accounts, investment accounts, stocks, anything like that should be titled in your trust. You can do an audit, and if they're not, then we can get that actually transferred into your trust. On the flip side, if something does happen to you before we get those things transferred in, there is a petition. It's kind of like a loophole with the trust. There is a petition you can send to court. It's called a Hague petition, and that's a way to petition the judge to allow us to put those items back into your trust even after you've passed away, saying that if you knew that these weren't properly titled, you would have put it in, but because you didn't, that's the only reason they weren't in the trust, but it was your intent to have them there. So then we can get a court order that allows us to retitle everything after your death into the trust and avoid probate. So we do have a little bit of a safety net there, but there are some restrictions and some evidence we have to be able to provide in order to get that court order.
Now, Barb, if you don't have the trust and you do have to go to probate, what can you give us an idea of like the price and the timeline that is associated with that?
Yes. So it's a sliding scale of percentages. The first $100,000 of your estate, the total aggregate of everything in your estate, is 4%. The second 100,000 is 3%. The next 800,000 is 2%. So you're looking at that as 21,000 right there for $1 million estate.
Yeah.
Above that, the next five, I think it's up to 5 million. Above that is 1%, and then it kind of goes 0.5%, and then kind of the percentages get smaller and smaller and kind of funky the way they do it. 0.5% of the first percent. So I mean, you're looking, if you have $1 million home, which in Morgan Hill in our area is very common, you're looking at least
price point.
You're looking at least 21,000 to your attorney. The same price applies to whoever the executor of the estate is. So now that's 42,000 out right there. That's not including the filing fees, which can be another 1,500 to 1,000 depending. The publication in Morgan Hill, I believe, is $400 to publish the probate in a newspaper. And then you have the probate referee appraiser who gets 1% of the appraisal value of the property. So that's, it just keeps adding up, right?
It's a cash grab, my gosh.
Yes. So doing a trust is pennies compared to what you'd be spending on a probate.
Well,
and then to initiate the probate, you file. Right now, the courts are chaotic right now, but you're looking normally at a 3 to 4 month time period to wait before you're even appointed as the executor of the probate. Then once letters are issued, even if it's a single house and you're just inheriting that house, you can't petition to close that until 4 months have passed after you've become the executor. And that's for creditor reasons, so that you can pay debts, give the statutory time for creditors to find you and make their petition for payment. So then that's another 4 months. So now you're at 7 to 8 months. So then once those 4 months have passed, you can file to close the petition, the probate. And then again, we're at the mercy of the court's calendar, which can be another 3 to 4 months. So now, I mean, it's a year. It's a year if everything's very smooth and you're lucky.
Wow. A year and like $50,000, $60,000.
Yeah.
That's a lot of money. Yeah. So of course, if you've passed on, it doesn't help you. But if you still have family left behind, then it certainly helps them. And I would imagine that the frustration and pain of going through a court process is really horrendous for a grieving family, for their loved one to have to deal with all of that. So it's, I've always said it's a very loving thing to do, to get a trust for.
And it's very triggering for the people that have to go through the probate. They rush out to get their trust done because after they've experienced it, they say, I don't want my kids to go through this. It was absolutely horrible. Let's just get this done, whatever it takes. I want my trust done.
So Barbara, in the case, let's say we have a lot of single people that don't have kids, they're not married, maybe they don't have nieces and nephews or cousins or any family that they would give to. Maybe they were a single child, their parents have passed on. There isn't anyone that they would necessarily will their estate to. They can put a charity in trust, right?
Absolutely.
They can really put anything in there.
So what I do is, even if they do have children or family members that they want to leave their estate to, there's always the end game that, if everyone's on a family vacation and, they all get hit by a bus, whatever the case may be, the default is 50% to one surviving spouse's heirs, 50% to the other surviving spouse's heirs. And there's a lot of instances where the person is estranged from their family and they don't want certain members of their family to inherit under any circumstance. So before we get to that, bottom line, we do insert charities or a different friend or person that they'd rather have inherit, rather than, refer back to that standard default to just closest living heirs. Okay,
good. Do we have any other questions, Brittany?
Not that I see right now. We did have a couple people join a little late, so maybe if we want to give it one more minute to see if anybody has one, but at this point, no.
That was a good brief rundown, Barbara. What are you offering for people that either need to get their trust redone? And I've been telling you for weeks, but I need to get you my trust. And see, this is what we do, right? We just put it
Well,
off, and then
I know.
okay.
Right now, just because I know there's a lot of financial instability and people have a lot of concerns with the chaos of the world right now, I am offering a free 30-minute consultation if you just want to see, where your estate would fit in, what exactly your needs would be, to get a price quote and anything like that. Feel free to make an appointment. You can go, I have an online calendar at pretlovelaw.com. That's P as in Paul, RETLOVELAW.com. You can sign up on there, or you can call and my receptionist will schedule that for you at 408-850-6402.
And her number and contact information is on the screen as well.
Oh, it's not on there. It's showing the questions, but.
Oh, I'm on, sorry. Let's see. There we go. I thought I was on that screen. Sorry about that. There is her contact information. If anybody needs to take a picture of that or snip it. And no other questions, Brittany?
Let's see. Nope, just from George Wong. He just said, thank you for answering the question and please send out Barb's contact information.
You got it. Thanks. Thanks for the question, George. So we went through those for all the questions. Thank you, Barbara. That was a really great kind of introduction to trust. Actually covered a lot and I learned a couple of new things. So thanks for giving us the update. You all have Barbara's contact information. So if you need to reach out to her, feel free, and she's fantastic and really fun to work with. So very, very, very knowledgeable. And I recommend that anyone that has real estate or is thinking of buying real estate, that you really do some estate planning, because it will save you a lot of money in the long run, and certainly your heirs and your family as well. To talk about what we're going to be talking about next week, I'm going to be doing a deep dive into the real estate market with an update. We'll have a mortgage update as well. Oh, Brittany, do you have another one?
No, I was waving at Barbara. She left to go to court.
And then Tuesday the 16th, all about buyers and how to buy a home in the Bay Area, how to get into a loan, how much money down do you need? That's the question I hear from buyers every single day that are so anxious to get into their first home in the Bay Area, but just feel like they can't do it. And there are so many creative things that are available right now in order to help people get into a home. And never say never. There's always a way. There might not be an opportunity right now, but let's get a plan together to get you into something really good that's going to get you off on the right foot into this amazing real estate market that we have in the Bay Area. And then Tuesday the 23rd, I'm going to be on vacation, so we won't have a meeting. I'll be at the beach in Oregon relaxing, and then we'll pick it up after that. So here's all my contact information, everybody. Oop, nope, here we go. Did I leave it? Can you see that? There's my contact information. And if you need to reach out to me anytime, feel free. My phone number is 408-577-7220. Email is dd.richards@cbnorcal.com. Love to help consult with you on your real estate needs, help you save as much money as possible with what you're looking to do, and help you build wealth through real estate. Thank you so much for attending today, and we'll see you next time. Take care. Be safe out there, everybody.
Bye, Dee Dee. Thank you.
Bye. Thanks.